personal data protection law to protect our rights in the digital world, thereby bringing India closer to a legislation that specifically lays down provisions for safeguarding personal data. In this edition of Sansad Dhwani, we're delighted to present to you a panel of influential technocrats and lawmakers. Shri Rajeev Chandrasekhar, Honorable Minister of State for Electronics and Information Technology, Government of India. Also, Union Minister of State for Skill Development and Entrepreneurship. He is a politician, entrepreneur, technocrat, and is serving his third term as a Member of Parliament in the Rajya Sabha from BJP representing Karnataka. He is a strong advocate of governance reforms. Welcome, sir. Shri Tejasvi Surya, Honorable Member of Parliament, Bengaluru South Constituency. He is also National President of the Bharatiya Janata Yuva Morcha. Welcome, sir. Shri Sharad Sharma, co-founder of iSpirit Foundation and Telshare Technologies. He is a member of the National Startup Advisory Council. He chairs the task force on DPI in the Think Tank 20 engagement group of G20. He is also an active angel investor, was instrumental in the success of India's first IP-focused fund, the India Innovation Fund. He previously held R&D leadership positions at Yahoo, Veritas, Symantec, Lucent, and AT&T. Digital Personal Data Protection Bill is a very significant milestone in PM Narendra Modi's vision of global standard cyber laws for India's digital economy. With this, now we will have opening remarks by our Honorable MP, Shri Tejasvi Surya. Yes, okay, sure. Sorry. Let's begin with Shri Sharad. So, the Digital Personal Data Protection Law has all the elements needed for data empowerment. So, let's understand more about what's the law and how it's going to affect you. Shri Sharad Sharma on the topic, what does the Digital Personal Data Protection Law mean for us? Over to you, sir.
Thank you so much. I know our Honorable MP was supposed to go first, and on the way over, he said, maybe, why don't you talk first? So let me give you the context, and I'm going to take you back in time, and through this journey, I'm going to make a conclusion. I'll tell you what that conclusion is. I think there are going to be only 3 AI superpowers in the world. And it's not going to be Singapore, it's not going to be any small country. It'll be, of course, India, China, and the US. And why I'm going to make my case to you, why this bill is pivotal to making that happen. Had this bill not happened, we would not have the potential to get there. And this is a slightly circuitous journey, so stay with me for a few minutes. I'm going to make 5 or 6 points and to get to this conclusion. First, I'll take you back to late 2013, 2014. By that time, it was clear that the digital revolution was going to be upon us. In fact, there were applications, some of you may remember. Does anybody remember News Hunt here? Bharat Matrimony? Zoho? These were consumer apps, Indian consumer apps, Indian business apps, and these companies have gone on to become even more successful. And I used to be an angel investor and a board member in Bharat Matrimony way back in 2007 and 9. That will tell you my vintage. And so it was clear that Bharat is going to adopt digital, because we as a society are an open society. We will adopt anything new that is useful to us. But there was a fly in the ointment, as they say. The fly in the ointment was that all these apps that we were talking about were built on digital infrastructure that was going to be foreign. It was app stores, cloud computing infrastructure, AWS used to be very popular then, and things like that were all coming from outside. And there's a worry that took over, saying we have the potential, while it looks very promising, we have the potential that we may again become a digital colony as we go forward. Right? So what's the answer to that? So a deep thought revealed a very simple answer to that. And I'm happy to tell you that has stood the test of time over the 10 years. And that was that if India could own the digital infrastructure that mediates the flow of people, flow of money, and flow of information, because then we will be fine. And you know what? At that time, we had to give this concept a name. That concept was named in a meeting that I have the privilege to be part of, and that concept is today called India Stack. How many of you here have not heard of India Stack? Everybody has heard of India Stack. India Stack in its essence is actually this digital infrastructure. And saying that this digital infrastructure should be Indian meant that it should be owned by the government. It should be owned by the public. So the idea that it should be public digital infrastructure was an idea that was born in 2014. But at that time, it was just an idea. There was nothing else there. Even eKYC did not exist at that time. And eKYC, e-sign, flow of people. And that allowed us to issue bank accounts to millions of people. We went from 17% to 81% in a very short amount of time. We are the largest user of e-sign in the world. Do you know e-sign is a national standard, but all the people who provide e-sign services are private players. Many of them startups here in Bangalore. It is an example of public infrastructure privately provisioned. You know, Bangalore airport is public infrastructure privately provisioned. Chennai airport is public infrastructure publicly provisioned. Which is a better airport? Exactly. So this idea that not only should we have digital infrastructure, not only should it be public in nature, but it should also be wherever possible privately provisioned public infrastructure is an idea that took root. And so the first layer was flow of people. The second layer that we thought of was flow of money, right? And that required work. Work on UPI started here in Bangalore in September of 2014. It was launched, as you know, by PM Modi, you know, the BHIM app, December 30th, 2016. And of course, UPI has been a success story, you know, in a big way after that, right? But along the way, there was a first attempt in solving this flow of information problem. And that is DigiLocker. Here, is there anybody who doesn't use DigiLocker? DigiLocker was launched by the PM on 1st July 2015. It was our first attempt to think about the flow of information. It's gone on to be very successful, but also realized that there were limitations in this approach. And the limitations was that it worked very well for documents, but information is not always documents. And an idea took root that we needed to think more broadly about this infrastructure in a way that had not been thought about anywhere else in the world. And so could we copy what the Americans were doing? No. You know why? Because Americans are very good in providing flow of information, but in that flow of information, they have very little respect for the privacy of the individual. And we wanted to make sure that the privacy of the information was in the hands of the individual. They controlled it. Now, the Europeans do a very good job of privacy of the individuals, but you know what? They do a terrible job in letting innovation happen in the ecosystem. So we didn't have the luck, and China model, of course, is not even copyable. Don't even get me started on China, right? So the question was, we had neither the opportunity to copy Americans, nor the opportunity to copy Europeans, and we had to find a system which would give us a balance, a good balance, without compromising the privacy. It would also allow us to give innovation. The first system in the world for data economy that allows you to do that is the Indian system. It combines, it gives you full privacy, but it also allows our entrepreneurs to be able to innovate on the back of information that we have. To allow for that to happen, a new concept had to be invented, and that is techno-legal regulation. So the bill that we see, you know, this Puttaswamy judgment happened in July. There was a committee that was set up to draft the bill. But also on 16th of August, this anniversary of which is coming up in a few days, 16th of August 2017, a technical system was launched called DEPA. DEPA is Data Empowerment and Protection Architecture. How many of you have heard of this? Very few. But how many of you have heard of account aggregator? I see more hands going up. account aggregator is built on the DEPA architecture. While the bill was being cooked, luckily for us, all the financial regulators led by RBI decided to pilot this system in the financial world. And so today in India, we have a system that the world can see, which is called the account aggregator system, where you control your financial data, and only under your control, with your electronic consent, can it be shared to anybody else, a lender or any other financial service providers. And this system was piloted from 2017 to 2019. Then a public pilot took place from July 2019, and it was formally launched in the public in September 2021. Today, it covers more than 1.1 billion bank accounts. It is growing. The number of consents that we have are growing at 32% month on month. 19 million people used it in this month alone as we go forward. And so this is a system which is growing very rapidly. So therefore this idea, the new idea that had to be born was techno-legal regulation. Can we regulate the market behavior of people, not only by public policy, but also by public technology? Public policy, public technology coming together will allow us to create good behavior in the market for people. That is called techno-legal regulation, right? And think of it, potter's wheel, you want to shape clay, you can't shape clay with one hand. You can shape clay only when you put both hands on the wheel. This idea of techno-legal regulation is an Indian innovation across the world. And then the bill started taking shape. Our Honorable Minister has been intimately involved in this, shaped every part of this. There was a JPC involved. Our Honorable MP was part of that JPC. He made sure that this view that was being espoused was pulled into the conversation, so that we were creating something that was going to be techno-legal in nature. So this is the innovation that India has brought in so far, right? This is not something vaporware, because a version of this is running as the account aggregator that you see today. Now, what does it mean? What's going to happen in the future? What's going to happen in the future is, because what this bill enables, I'll give you a very, very simple example so that you can relate to this. Every company, let's take a company that you're all familiar with, railways, right? IRCTC. They issue railway tickets to us, right? So they have some personal information about me. They also have aggregate information, seasonal patterns, when do people travel, when do they travel, when do we see more travel in which season to which city, and so on and so forth. They have aggregate information. If they were in the US, what they would have done is, they would have taken this personal information and they would have resold it to anybody, right? Because in the US that is allowed. Or if they were in Europe, they couldn't have given it to anybody, even if you wanted them to give it to them. But in India, it is possible for your personal information to be shared to somebody else, but only with your consent, only with your electronic consent. And our electronic consent system that we have is organs. Remember this. It's open, it's revocable, it's granular, it's auditable. It notifies you when something happened, and it's fully secure. No other country has that system. Second, if you want to look at the seasonal pattern, let's say Make My Trip, Clear Trip come to them and say, hey, I want to look at this aggregate data. Will you share your aggregate data with you? They would share this aggregate data if they were in the US. But what if one of those companies de-anonymized this data? They gave it in an anonymized form, but anonymization is an art form. It's not a science. You can de-anonymize that data. And what if they de-anonymize that data? What would be the consequences of that? Damage is done by that. Right? Now, in the US, they control it by having very large penalties. You've heard of that you'll sue somebody and then bad things will happen. India, our legal system doesn't allow us to do that. So that deterrence is not there at all. So we needed to invent a system where technology will provide us computational guarantees on privacy on aggregate data. That system is called the DEPA training cycle. How many of you are techies here? Go and check the system out, depa.world. Now, why is it called depa.world? Why is this Indian system put under a thing called depa.world? You know why? Because even today, other countries want this system. We are the only game in town that has a data economy system which balances innovation and privacy, techno-legal in nature, implemented for millions of people and working at scale. And the law, what it does is it provides now this enabling environment for this to explode as we go forward. Now, what does that explosion mean? That explosion means that all of us here, a few years from now, maybe not even years, maybe a year or two from now, will use some form of AI to be a better student, to be a better teacher, right? On the other hand, unfortunately, what is also going to happen is that gaming, gambling, even pornography will use AI to distract our youth in a way which is worse than what happens today. And we have the world's largest population of young people. So we need to find regulation to do that. This is why China bans games after 8 o'clock. you can't consume games in the Chinese system after 8 o'clock because they're trying to protect their young people from getting distracted. We can't use the Chinese way for making that happen. But we need a techno-legal regulation to be able to prevent that distraction economy from becoming more powerful. And the augmentation economy becoming powerful, but becoming powerful on the back of AI models that are built in India, not AI models that are coming from China and the US, right? For that, who will own the AI models? Are the people who own the data which feeds those models, which trains this model. There are only going to be 4 continents that can have continental scale data for training AI. US, of course, will do it. China, of course, will do it. Europe is lost at this point in time. India has just put in place with this act a system that unlocks in a completely privacy-preserving way continental scale data for Indian entrepreneurs to build world-class models from India. That is the reason why India will be an AI power of the future. We have our own problems to solve with AI. We have our own data that we can use to train our models to solve that problem. And we have the talent, all of you. In fact, the most famous AI paper which is driving this revolution is a 2017 paper on Transformer. Count the number of Indians in that paper. The lead person is himself Ashish Vaswani, an Indian. Indians are driving the AI world today, even as we speak. So we have the talent. We are going to bring all of this together to solve our hard problems with Indian AI based on Indian data and thereby be a shining example for the rest of the world. Thank you so much to both of you for helping laying the foundation for this in a very powerful way. So we have a good India to look forward to in the future. Thank you so much.
Thank you, sir, for outlining the technical and legal provisions under this law to create an enabling environment to build world-class models from India. Moving on, let's hear from the minister himself. So, yes, thank you, sir.
Thank you. Everyone, namaskara. Good evening. I won't try and speak to you on digital personal data protection in Kannada. Adu beda. I'll confuse you, confuse me, and the whole objective of the Sansadvani will be defeated. So I will speak in English on the subject. First of all, thank you to my colleague in Parliament and our representative in Parliament, my representative in Parliament as well, Tejasvi Surya ji. Shri Sharad Sharma, who's also already given you his views. And to all of you, good evening. Just a small correction to the MC. The bill is already notified, so the bill is not in Lok Sabha alone. It is Lok Sabha, Rajya Sabha, the President of India, and it has been gazetted today, so it is law. The Digital Personal Data Protection Bill is law as of today. And let me share some of my thoughts on the bill and, of course, the context in which that bill is important. First of all, I have been here before. I have spoken to. I don't know how many of you in this audience have already met with me and spoken to me, but certainly you remember that to those who have met me, you remember I was here a few months ago and I laid out Honorable Prime Minister Narendra Modi ji's vision of this new India, which is being built around young Indians such as yourself, and more opportunities for young Indians. He coined a phrase on 15th of August 2021 called India Techade. India Techade to you should mean a lot, because it's really, he's envisioning a decade full of technology opportunities for those who are students today, who will be in the workforce tomorrow, who will be entrepreneurs tomorrow. The India Techade is an exciting vision, and therefore I always, when I meet students in colleges, I say, simply with a little bit of envy on my part, and on behalf of all grey-haired people of the world, that you are certainly the luckiest generation in the history of independent India, because of how exciting the present and how exciting the future looks for you, that is being built out by policies, the hard work, determination of our Prime Minister, who, amongst other things, is the biggest believer in the potential and the capabilities of the youth of India. What is digital privacy? What is digital personal data protection? Another law. I mean, you saw in the last 2 weeks plenty of disruptions, and you must have scratched your heads if you were watching TV and saying, what is the point of these people in Delhi and what good will come out of them in Parliament? But I can certainly tell you that this bill is certainly one of the goods that has come out of Parliament despite the disruptions. And so what is the history of this privacy? Where does this conversation start? Why is this bill so important? Some facts have been laid out by Mr. Sharma, but I will give you, certainly as somebody who's been a traveler on pretty much that entire journey, I will certainly want to share with you that background, and then I'll get into the bill. In 2010, I was a member of Parliament. I was certainly not in the government, and it was the UPA Congress government at that time. I introduced in Parliament a private member's bill asking for privacy to be declared a fundamental right. The government of the day, of those days, felt that that was not necessary. They ignored any call for debate in Parliament, and they continued business as usual. And essentially, personal data of Indians were flying all around the country. It was available, and I remember once in Parliament raising a sheaf of personal data which I had bought in Palika Bazaar of Connaught Place for 50 rupees, which gave me name, address, telephone number, date of birth, everything. And that was just floating around as if that meant nothing to the people whose data it was. So in 2013, a group of us in Bengaluru, and this is why it's important that you in the audience as Bengalurians understand that in a lot of ways this bill, the genesis of this bill was in Bengaluru. So Justice Puttaswamy, there was a Colonel Matthew, and myself as petitioners filed a PIL in the Supreme Court. And the journey from 2013 to 2017 resulted on the 24th of August 2017. And by that time, Prime Minister Narendra Modi ji was already Prime Minister. People had voted him in. And in 2017, the Supreme Court found that privacy is a fundamental right. Prime Minister Narendra Modi ji got his team to swing into action to codify that into a legislation. And the first draft of that legislation came about in mid-2019 after a series of committees, including the Justice Sri Krishna Committee report, had been sought for and asked and submitted. So 2019, the draft bill was tabled in Parliament. That was referred to a joint committee of parliament in which Tejasvi also was a member. I was also a member. And that, unfortunately, during COVID, took about 1.5, 2 years for a report to come out. But what came out on the other end of that discussion was a very complex, highly complex bill that would have certainly protected citizens' rights, but would have put a brake on innovation, would have slowed down innovation, created compliance burdens for our young startups. And so the Prime Minister agreed to our request that we withdraw that bill and go back to the drawing board. And that happened on the 22nd of October 2022, and then we have the bill as was passed in Parliament, Lok Sabha, Rajya Sabha, and then notified by the government. So I just wanted to give you this journey of almost 10 years where this issue of privacy started being debated, and finally we now have a world-class legislation. Why is a world-class legislation so important? And I will go back to the first point that I made, that the next 5-7 years represents so much technology and innovation opportunity for India and Indians and young Indians and startups that is almost certainly requires an enabling framework of law that permits this, catalyzes this, and accelerates this, rather than impedes it or breaks it. Which is why the Honorable Prime Minister said we need new laws, modern laws, which are designed, developed with the participation of our young Indians, entrepreneurs and startups, so that these bills, these laws work for them. These laws are not meant to satisfy some MPs or some large businesses. These laws are being framed by our government, by Parliament, so that for all those of you who are going to be entrepreneurs in the short term, in the long term, in the future, these legislations, and you must have noticed that I've used the word plural in legislations, and I'll explain why I use the plural. Like DPDP, enable that future, enable that India Techade, enable the $1 trillion digital economy goal that we have. That is the background. Now, what is privacy and why is privacy so important? One of the defining features of the last decade of digitization in the world, whether it is social media, whether it is this platform, that platform, has been the almost unfettered, at least in the Indian context, unimpeded, without consequence use of personal data by platforms. And those platforms could use your personal data not just to deliver your service or deliver your product, but then to do all kinds of other things, including causing harm. Intended, unintended, intentional, unintentional, witting, unwitting. This behavior, this bad behavior, this exploitation, this misuse of personal data is an open secret. I think all of you know, you get calls from people, you go to a website, you log in and you order something, and suddenly 2 days later you have something else being thrown at you. So the misuse and exploitation of citizens' personal data is something that many platforms have been doing. And of course, they will argue it is in your interest and it's great and it's very good and it's not causing harm. But it's certainly, in many, many cases, causing harm and certainly violating the Supreme Court's finding that privacy is a fundamental right. So for this bill, just to describe what this bill achieves. First of all, it puts a brake on the practice, brake as in B-R-A-K-E, brake, on the practice of misuse and exploitation of personal data without consent. So if you are one of you, No platform can now use your personal data without you saying, yes, I agree. And for them to get that yes, they have to ask you that question in a meaningful, informed manner. And this is at the heart of this Digital Personal Data Protection Bill. And this is absolutely consistent and in line with our Prime Minister's vision, philosophy, that citizens' rights, as we talk about innovation, as we talk about real estate, everywhere, he says, at the heart of every public policy, we must enshrine what the rights of our citizens are. So that is why about a few years ago, you remember there was a bill called RERA, the Real Estate Regulation Act, that dealt with the asymmetry between home builders and those who are buying homes. And that has, in a lot of ways, dealt with that asymmetry and created an equal culture of accountability and rights for the citizens who buy. Same way here, the DPDP at its heart creates these rights for all of you, every citizen of India. And without your consent, no platform, neither government nor private, can access your personal data. So that is point number one. Point number two is about data minimization. Assume for a minute I'm a platform, I'm delivering food. I certainly have no business asking you what your grandfather is, who your grandmother is, where is your ancestral home, what is your blood group. I should ask you for your credit card number and ask you for the delivery address. So data minimization says, any platform that asks you for data to deliver a product or a service that you want should only ask for the minimum amount of data that is required to deliver that service. Third, purpose limitation. This is very important. A platform that takes your personal data can only use it for the purpose that you have consented to. So in the consent, if you say, I give Mr. Zomato my home address and my credit card number, I certainly don't give that food delivery platform my consent to use my details for anything other than delivering my food. That is purpose limitation. And the third is storage limitation, which is that you cannot store the data, my data, your data, personal data, for any longer than that is required to deliver the service. So the question of creating big databases of personal data that have been collected to deliver a service and then to use that for something also stops. These are the 3 or 4 basic principles that have gone into the DPDP that at the heart of it go to creating or codifying the rights of every Indian citizen that deal with platforms that have to use their personal data. On the other hand, reciprocally, the obligations of platforms have been defined in a manner that are so simple and easy to read and understand that even the smallest of startups to the biggest of big tech companies from around the world will find it easy to understand and comply with without having to worry about hundreds of lawyers. And it may certainly, one of the arguments of the DPDP is that it will put lawyers out of business, which is not a bad thing, I believe, anyway. But certainly this is not something that has a huge compliance overhead or complexity. And so we expect 2 things to happen after the bill is promulgated and notified and is operationalized, and we'll certainly have a transition period because it's moving to a new regime. So we will give industry, we will give companies time to transition to this new regime. But the consequences, like I said, is that era of misuse, the era of exploitation, the era of platforms believing that Indian citizens did not have rights and their personal data can be used and exploited in multiple ways comes to an end with this bill. But this bill is a very important marker for the catalyzing the innovation ecosystem, because it removes any ambiguity about what a startup or what a company is supposed to do when privacy has been declared a fundamental right. Earlier, there were all types of formulations. People were worried, is this violating, is this compliant, is it harmonized? Now there is none of that. It's an absolutely simple, clear, transparent framework for companies and for citizens. And whenever there is a dispute, for argument's sake, some company breaches its data or breaches its obligations, all the citizen has to do, it doesn't have to run around from place to place, go to a website, send out the details of the breach to the Data Protection Board, and the Data Protection Board will start the investigation of the breach and levy penalties on the breaching platform that could be as high as 250 crores per breach. Now, again, I want to explain to you when people say, and you will read a lot of editorials, oh, this happened, that happened, and all that. The idea of the government is not to make money by incentivizing companies to breach data. I certainly want to clarify that. We wanted to make the penalties so punitive that there is an incentive for platforms to behave themselves in a responsible manner vis-a-vis Indian citizens. So the penalties are not any way for the government to make money or for anybody to make money, but they are there to ensure that platforms understand that the government of India takes the duty to protect the rights of our Indian citizens very seriously, and that any erring platform will have to pay significant financial consequences. And just to give you an idea of what the financial consequence could be, in a worst case scenario, let us say a database with 10,000 entries is breached, and there are 10,000 entries that have been breached, the financial penalty could be as high as 10,000 times 250 crores. That's a lot of zeros. That's more zeros than A. Raja and the 2G scam. So that's a lot of zeros. So I've explained the the DPDP. I certainly, you're all young, smart minds, would request you to read it. They're all available online. Very simple English. The ladies will, in the audience, will like it because the gender of the bill is that of a woman. So it is almost that the bill refers to every Indian as a female gender, and so that is also a first in terms of legislation and bills in this space. So please do read it, and please be aware of the rights. Please, amongst your own friends, make it known to others what this is about. And you're all more digital than all of us. So you are now getting into this digital world with a lot more safeguard and guardrails that were not there in the past. I certainly want to make a couple of other points before I wind up. One is about this debate on GDPR. And there has been a fashion in this country, and you know that there are many people who think anything foreign is automatically the best. And so there has been a history that every privacy and data protection conversation in India almost starts with a conversation on GDPR. And GDPR, by the way, is the European Data Protection Act. And one of the things we decided when we started designing this bill is that we will design this bill ground up from an Indian bill, as an Indian bill. And so we have made no efforts and attempts to even pretend that this is similar to GDPR or it is derived from or inspired from GDPR. We have looked at the Indian internet with 830 million Indians today who use the internet. By 25-26, that will be 1.2 billion Indians. We are the largest connected country in the world. We are the largest single group on the global internet. And so I think you will agree with me that we deserve to be setting the standards and the basis for any conversation about technology for the future rather than borrow anything from Europe or the US going forward. So therefore, this bill, if anybody comes to you and says, no, but it's not like GDPR, it's all that will happen. Say, no, this is the Indian Digital Personal Data Protection Bill. And that's it. And I'll give you one little experience I had. I was in Dubai in a conversation like this with the digital minister of Dubai, Abu Dhabi, UAE. And a lady journalist, foreign journalist, stood up and said, but your Indian bill doesn't look like the GDPR. And so I was prepared to go give my long response to that. But my friend and colleague from the United Arab Emirates said, and I think he said it beautifully, he said, look, India is leading the world, and now it's time for the world to follow what India is doing in terms of rules and regulations. So that is where we are as a country. We have the confidence. You represent the future energy that we have in terms of what we will do in the tech space. I will just end by saying one more thing. That is that the companion bill to this, that you will soon hear about in this month itself, is something called the Digital India Act. And that is why I was using plural in the legislations. The Digital India Act will replace the IT Act, which is a 22-year-old legislation. The Digital India Act will go into consultations very soon. The pre-consultation for that act was done in 4 locations, including one in Bangalore. And that went off very well. And the Digital India Act will deal with the whole ecosystem of tech. The Digital Personal Data Protection Bill deals with a very narrow slice which relates to regulation and rights of consumers and obligations of platforms relating to personal data. But the entire other world, including that of emerging technologies, etc., will be dealt with the Digital India Act. So I just want you to be ready to be engaged on that as well. Thank you for your time. I hope this has been useful for you. Certainly always a useful thing for me to engage with all of you, especially students. Thank you. Jai Hind.
The Honorable Minister, Shri Rajeev Chandrasekhar, has personally led with all stakeholders to make the Indian DPDP a global standard, contemporary, future-ready, yet simple and easy to understand. Thank you, sir. So with this, I would now request our Honorable MP, Shri Tejasvi Surya, who is also a member of the Standing Committee on DPDP. So I look forward to hearing from you. Thank you.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಇವತ್ತು ಬಹಳ ಸಂತೋಷದ ಕಾರ್ಯಕ್ರಮ. At the very outset, I would want to thank the Honorable Minister of State for Information and Technology and Skill Development, who has played a pivotal role in making the Data Protection Act a reality today, who is also a Rajya Sabha MP from Karnataka and is most importantly a resident of Bengaluru South, our very own Shri Rajeev Chandrasekhar ji, for not only taking pains to make this act a reality today, but also attending the very first public engagement program being held in the country after the act has formally gotten the President's assent. Thank you so much, sir. I also want to thank Shri Sharad Sharma, man who wears multiple hats, a very respected technocrat who has always provided critical inputs to government to help in the country's digital transformation. I recollect with a lot of gratitude the multiple times that I have relied on him and his young team to advise me and other members of the Joint Parliamentary Committee on important facets of this bill at the time that the Joint Parliamentary Committee was discussing this bill threadbare. At more than 2 or 3 occasions, he and his team have come as witnesses before the JPC and have deposed and have presented their views, and many of the views have also found their expression in the today's version. ಬಹಳ ಖುಷಿ ಅಂತಂದರೆ ಈ ಬಿಲ್ಲು ಇವತ್ತೇನು ಆ್ಯಕ್ಟ್ ಆಗಿದೆ ಅದರಲ್ಲಿ ಬೆಂಗಳೂರದು ಬಹಳ ದೊಡ್ಡ ಪಾತ್ರ ಇದೆ. ಯಾಕೆಂದರೆ ರಾಜೀವ್ ಚಂದ್ರಶೇಖರ್ ಅವರು ಈ ಇಡೀ ಹೋರಾಟ ಪ್ರಾರಂಭ ಮಾಡಿದ್ದು UPA ಸರ್ಕಾರದ ಟೈಮ್ನಲ್ಲೇನೆ. ಅವರಾಗಲೇ ಹೇಳ್ತಾ ಇದ್ರು, ಇವತ್ತು ನಮ್ಮಲ್ಲಿ ಬಹಳ ಜನ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಫ್ ಲಾ ಕೂಡ ಇದ್ದೀರಿ. The right to privacy is synonymous today with the Justice Puttaswamy judgment. ಆ ಜಸ್ಟಿಸ್ ಪುಟ್ಟಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟು ಒಂದು ರೀತಿ ಗಂಗೋತ್ರಿ. ಅಲ್ಲಿಂದ all of these principles which were enunciated in the judgment found statutory explanations and regulations in the form of this act. So on behalf of a lot of young Indians, crores and crores of young Indians, and especially on behalf of young Bengalurians, we would want to thank Shri Rajeev Chandrasekhar with a lot of gratitude for leading this very important 21st century battle from the very front. Thank you, sir. Friends, both Sharad Sharma ji and Rajeev ji have highlighted the different facets of this act. Of course, we are looking forward to a very engaging question-answer session. This is a very interesting audience today. There are law students, there are young CEOs from startups in the city, there are very senior veterans in the space of data protection like Na Vijay Kumar ji, who is here, who has been working in this space from so many decades. There are journalists who have been working in this space. I'm sure this is going to be a very engaging question-answer session. I would want to keep my comments very brief. The very first aspect of this bill is the one that Rajeev ji was highlighting at the very end of his remarks. Yesterday, if you have observed the proceedings in Parliament, the Honorable Home Minister moved 3 very critical bills which are going to replace the foundational texts of the Indian criminal justice system. The Indian Evidence Act, the Indian Penal Code, as well as the CRPC form the foundational texts of the Indian criminal justice system. All of these 3 legislations were intended, legislated, and enacted by the British. The objective of the Indian Evidence Act as well as the IPC was to primarily serve the interests of the British Crown at the expense of the native population. It was not done to further the interests of Indians and the interests of the Indian government. So what the Home Minister essentially has done yesterday is to make a very important journey towards finally decolonizing India's criminal justice system after 75 years of independence. As students of law, you would all appreciate that even the drafting of the Indian Constitution was heavily inspired from both the Irish constitutions as well as the constitution of many common law countries across the world. And we borrowed liberally from the Government of India Act of 1935. So most of our legislation, starting from the constitution to our penal legislations, we have done two things. ಮೊದಲನೇದು ನಾವೇನ್ ಮಾಡಿದೀವಿ ಅಂದ್ರೆ, ಬೇರೆ ದೇಶ ಈಗಾಗಲೇ ಮಾಡಿರೋ ಕಾನೂನನ್ನ ಫಾಲೋ ಮಾಡಿದೀವಿ ಲಿಬರಲ್ ಆಗಿ. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಇನ್ಯಾವುದೋ ದೇಶ ಈಗಾಗಲೇ ಮಾಡಿರುವಂತಹ ಕಾನೂನನ್ನ ಆಸ್ ಕ್ಯಾಚ್ ಅಪ್ ವಿ ಹ್ಯಾವ್ ಫಾಲೋಡ್ ಇಟ್. ಅಂದ್ರೆ ನಾವು ಬಿಲೇಟೆಡ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಫಾಲೋ ಅಪ್ ಮಾಡಿದ್ದೀವಿ. ದ DPDP ಇಸ್ ದ ಫಸ್ಟ್ ಸಚ್ ಲೆಜಿಸ್ಲೇಷನ್ where we have neither played catch up to the other jurisdictions, nor have we liberally copied or borrowed from other jurisdictions. This is in every aspect a legislation made in India, made for India, and made by India. This is a very important aspect of this legislation. To be a little selfish, I would add that though this is made for India, it is largely made in Bengaluru and contributed greatly by people of Bengaluru. ಅದರಲ್ಲೂ ಒಂದು ಮುಂದೆ ಹೋಗಬೇಕು ಅಂದ್ರೆ ಬೆಂಗಳೂರು ಸೌತ್. ರಾಜೀವ್ ಚಂದ್ರಶೇಖರ್ ಅವರು ಅಲ್ಲಿ ಮುಖ್ಯವಾಗಿದ್ರು. ಶರದ್ ಶರ್ಮಾ ರೀತಿ ಬಹಳ ಜನ ಅದರಲ್ಲಿ ಟೆಕ್ನೋಕ್ರಾಟ್ಸ್ ಇನ್ಪುಟ್ಸ್ ಕೊಟ್ಟರು. ಶರದ್ ಶರ್ಮಾ ಅವರು ನಮ್ಮ ಬೆಂಗಳೂರು ಸೌತ್ ಅಲ್ಲೇ ಇರೋದು. ಅದರ JPCಯಲ್ಲೂ ಆಸ್ ಮೆಂಬರ್ ಆಫ್ ದಿ ಬೆಂಗಳೂರು ಸೌತ್ ಪಾರ್ಲಿಮೆಂಟ್ ನಾನು ಅದರಲ್ಲಿ JPCಯಲ್ಲಿ ಇದ್ದೆ. ಅಂಡ್ ವಿಟ್ನೆಸಸ್ಗಳಲ್ಲಿ ಬಹಳ ಜನ ಬೆಂಗಳೂರಿನವರು, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಲಾಯರ್ಸ್ ಹೂ ಆರ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಇನ್ ದ ಪ್ರಿವಸಿ ಲಾ ಡೊಮೈನ್, ಬಹಳ ಜನ ಬಂದು ಅದರಲ್ಲಿ ಡಿಪೋಸ್ ಮಾಡಿದ್ರು ಆಸ್ ವಿಟ್ನೆಸಸ್. ಸೊ ಇನ್ ದಟ್ ಕಾಂಟೆಕ್ಸ್ಟ್ ಆಲ್ ಆಫ್ ಅಸ್ ಕ್ಯಾನ್ ವೆರಿ ಪ್ರೌಡ್ಲಿ ಸೇ ದಿ 21st ಸೆಂಚುರಿ ಇಂಡಿಯಾದು ಟೆಕೇಡ್ನ ಲಾ ಒಂದು ಫೌಂಡೇಶನ್ ಕೊಟ್ಟಿರುವಂತಹ ಕಾನೂನಲ್ಲಿ ಬೆಂಗಳೂರುದು, ನಮ್ಮ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆನ್ಸಿದು ಬಹಳ ದೊಡ್ಡ ಒಂದು ಪಾತ್ರ ಇದೆ. ಇನ್ನೊಂದು ಆಸ್ಪೆಕ್ಟು, a very interesting aspect of this bill is any legislation for a policy maker. ನಾವು ಲಾ ಅಲ್ಲಿ in the very first classes on law school, ನಮಗೆ interpretation of statutes ಅಲ್ಲಿ they start teaching us this concept of harmonious interpretation. The challenge for any lawmaker is how to harmoniously balance two apparently opposite concepts and objects. How do we balance two diametrically opposite ideas which are very much essential to make a systematic society run? This is a challenge for any policymaker. What the government led by the Honorable Prime Minister has done very successfully in this legislation is they have tried to and succeeded in harmoniously balancing privacy as well as processing, regulation as well as space for innovation and freedom, balance between the sovereign interests of the state as well as the individual rights of a private individual. This is something that this bill has so beautifully and successfully managed to address. Yake, I'll give an example. If there is blanket regulation that you cannot process data at all, what will happen to the 90,000 plus startups which have just entered the startup revolution? All of them will die a very natural death. So you need to make space for innovation. At the same time, you should also make space for protecting the privacy of an individual. This is balanced. At the same time, a government has many sovereign needs. For example, ಯಾವುದೋ ಒಂದು terrorist attack, ಯಾವುದೋ ಒಂದು ಮಾಡ್ಯೂಲ್ ಇದೆ, ಸ್ಲೀಪರ್ ಸೆಲ್ ಇದೆ. Just as we speak today, NIA has arrested 15 plus people in Bengaluru who are suspected of fomenting terror activities in the city. So whether it is preventing waging war on the state, whether it is protecting any of these very important sovereign interests, or maintaining the interests of a private organization or the privacy of an individual citizen. This is another very important balance that needed to be struck. E bill nalli, both of these very important aspects, ensuring that the government does not overreach and does not peep into our personal lives, as well as the fact that the government needs enough material, enough ammunition, enough strength to maintain law and order, peace and security and sovereignty, integrity of the country. That is also something that is taken care of in the bill. The other important aspect, Sharadji was mentioning about this in the course of his remarks. When the first version came, where Rajeevji was also a member of the JPC, later he got promoted and the good fortune of contributing much closely in the making of the legislation. There were various categories of personal data that were envisaged. The earlier version of the bill. Personal data ಅಂತಂದ್ರೆ ಈ ಹಿಂದಿನ ಬಿಲ್ ಅಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಕ್ಯಾಟಗರಿ ಕೊಟ್ಟರು. ಕೆಲವುದು ಕ್ರಿಟಿಕಲ್ ಪರ್ಸನಲ್ ಡೇಟಾ, ಸೆನ್ಸಿಟಿವ್ ಪರ್ಸನಲ್ ಡೇಟಾ, ಈ ತರ ಬೇರೆ ಬೇರೆ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ ಡೇಟಾನ ಬೈಫರ್ಕೇಶನ್ ಮಾಡ್ತು. ಅಂಡ್ the original thinking was that certain aspects of personal data, which is not critical, which is not sensitive, can be processed here, some cannot be processed. ಈ ತರ ಬೇರೆ ಬೇರೆ ಡಿಫರೆಂಟ್ ಕ್ಯಾಟಗರೀಸ್ ಆಫ್ ಪರ್ಸನಲ್ ಡೇಟಾಗೆ ಡಿಫರೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಆಫ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಹಾಕೋತಾರೆ. The second version of the bill that has now become the Act has completely done away with this concept of different categories of personal data. There is only one category of personal data, and it is all-inclusive category of personal data. So every aspect of personal data of every single individual, every single Indian, is to be treated with the same amount of respect and the same amount of sensitivity. This is again something which is very different from what GDPR or other jurisdictions have envisaged. This is another very important aspect. Like Rajeevji was telling, GDPR al hagide, innondral higide. We have gone a step further. We have said every aspect, every dimension of an individual's data is sensitive data. Every aspect of an individual's personal data is critical data. Therefore, there is no differentiation between the kinds of personal data in this. The other aspect, generally when laws are made regarding spaces like privacy or criminal jurisdictions, government and its instrumentalities and private organizations are generally treated differently. With government and its instrumentalities given a little more leverage, a little more liberal space to occupy. The difference in this bill is the rules apply as stringently to a government organization or instrumentality of the state as much as it affects or implements on any private organization in the country. So there is no artificial differentiation or a theoretical differentiation that is made between a government entity and a private entity. If Facebook does something wrong, it will pay the same penalty as if, say, a BSNL will do. So, idu innondu game-changing aspect that has been put in this thing. ಇನ್ನೊಂದು ಸರ್ಕಾರಕ್ಕೆ ನಾವು ಕೊಡಬೇಕಾಗಿರೋ ತುಂಬಾ ದೊಡ್ಡ ಕ್ರೆಡಿಟ್ ಅಂತಂದ್ರೆ, the beauty of this legislation is, from the first line to the last line, any person, even without a background in law, can read the legislation in one sitting and understand the whole of it. ಅಷ್ಟು ಸಿಂಪಲ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ ಈ ಲೆಗಿಸ್ಲೇಷನ್ ಬರ್ತದೆ. Legislations earlier would be written in the interests of lawyers. Legislation in this manner, in this case, has been written in the interest of the data principle or the citizen of India. So, special congratulations to the government, to the Prime Minister and his entire team of such efficient ministers. Andre, for making it a very simple legislation which does not even have a single proviso. This is the first legislation of this kind. Generally, you will have seen there's a first line in every legislation, adra kelgade baratte, provided that. And then adra kelgade baratte, notwithstanding anything mentioned here in above. And then it starts. Really, any normal person will not even understand what this is. But this is a legislation where the language is simple, language is direct, and there is not even a single proviso in the whole of the legislation. This is a very important step towards maturing ourselves as a nation that drafts and legislates simple laws for the interest of the individual. This is another very important philosophical step the government has taken. The other thing, other 6 principles of the Act, everything Rajeev ji has covered, I wouldn't want to repeat. I would only want to say this. Generally, ನೀವು ಇವಾಗ ಫೇಸ್ಬುಕ್ ಯಾವುದೋ ಒಂದು ಆ್ಯಪ್ ಡೌನ್ಲೋಡ್ ಮಾಡ್ತೀರಾ. ಆ ಆ್ಯಪ್ ಡೌನ್ಲೋಡ್ ಮಾಡ್ತಿದ್ದಂಗೆ ಅದು ಟರ್ಮ್ಸ್ ಆ್ಯಂಡ್ ಕಂಡೀಷನ್ಸು ಅದು ಇದು ಅಂತ ಕೇಳುತ್ತೆ. ಲೈಫಲ್ಲಿ ನಾವು ಇವತ್ತಿನ ತನಕ ಒಂದೇ ಒಂದು ಸತಿನೂ ಆ ಟರ್ಮ್ಸ್ ಆ್ಯಂಡ್ ಕಂಡೀಷನ್ಸ್ ಯಾರೂ ಓದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಅದಷ್ಟು ಫೈನ್ ಪ್ರಿಂಟಲ್ಲಿ ಇರುತ್ತೆ, ಅದಷ್ಟು ಉದ್ದ ಇರುತ್ತೆ. ಎಲ್ಲರೂ ಅಂತ ಸ್ಕ್ರೋಲ್ ಡೌನ್ ಮಾಡಿ ಅಕ್ಸೆಪ್ಟ್ ಆಲ್ ಅಂತಂದು ಹೊಡೆದು ಮುಂದಕ್ಕೆ ಹೋಗ್ತಾ ಇರ್ತೀವಿ. ಬಟ್ ದ ಡಿಫರೆನ್ಸ್ ಇನ್ ದ ಕಮಿಂಗ್ ಡೇಸ್ ವಿಲ್ ಬಿ that the consent notice has to be simple, it has to be specific, it has to tell the individual why your consent is being sought, for what purpose it is being sought, for what duration it is being sought, and it must be communicated to the Indian citizen, not just in the English language, because it is a language of the privileged class in India. It must also be communicated in all regional languages recognized in the Constitution of India. There was this very interesting question, Rajeev ji, that came up in the course of our discussion in the JPC. This was from a member of the Congress party. He said the very concept of privacy is very elitist. He said that this legislation itself is for the elite. Because the poor man perhaps may be not concerned or maybe not even aware that there is a concept called privacy that exists. Perhaps nobody can be as far away from reality and far away from truth as that kind of a statement. Because privacy is the fundamental right of every single individual. And English ಬರ್ಲಿಲ್ಲ ಅಂತಂದು ಮಾತ್ರ ಅವನಿಗೆ ಪ್ರೈವಸಿ ಇಲ್ವಾ ವ್ಯಕ್ತಿಗೆ? ಸೊ ಈ ಬಿಲ್ಲಲ್ಲಿ ನಾವು ಮಾಡಿರುವಂಥ ಬಹಳ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಕೆಲಸ ಅಂತಂದ್ರೆ, ಕನ್ನಡದವರಿಗೆ ಕನ್ನಡದಲ್ಲಿ ನೋಟಿಸ್ ಸಿಗಬೇಕು, ತಮಿಳು ಮಾತನಾಡೋರಿಗೆ ತಮಿಳಲ್ಲಿ ನೋಟಿಸ್ ಸಿಗಬೇಕು. ಯಾವ್ಯಾವ ಭಾಷೆ ಭಾರತದಲ್ಲಿ 8th ಶೆಡ್ಯೂಲ್ ಆಫ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ನಲ್ಲಿ ರೆಕಗ್ನೈಸ್ ಆಗಿದೆಯೋ ಆ ಎಲ್ಲ ಭಾಷೆಗಳಲ್ಲಿ ಈ ನೋಟಿಸ್ಸು ಜನಕ್ಕೆ ಸಿಗಬೇಕು. ಇನ್ನೊಂದು ಲಾಸ್ಟ್ ಪಾಯಿಂಟ್ ದಟ್ ಐ ವುಡ್ ವಾಂಟ್ ಟು ಸೇ ಬಿಫೋರ್ ವಿ ವಿಲ್ ಟೇಕ್ ದ ಕ್ವೆಶ್ಚನ್ ಆನ್ಸರ್ ಇಸ್ ದಿಸ್. ಶರದ್ ಜಿ ಹೈಲೈಟೆಡ್ ದಿಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್, ವೆರಿ ಕ್ರಿಟಿಕಲ್ ಪಾಯಿಂಟ್, ಅಂಡ್ ಇದನ್ನ ಫಾರ್ ಅ ಲಾಂಗ್ ಟೈಮ್ ವಿ ಡಿಸ್ಕಸ್ಡ್ ಅಂಡ್ ಅವರು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು ಅಂಡ್ ವಿ ಡಿಸ್ಕಸ್ಡ್ ಇಟ್ ಇನ್ JPC. The game-changing aspect of this bill is how this is going to be executed. Now you will all ask, generally in the course of our conversations we keep telling alva, India ಕಾನೂನ್ಗೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಸರ್, ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಪ್ರಾಬ್ಲಮ್ಮು, ಎಲ್ಲ ಕಾನೂನು ಇದೆ ಅಂತ. ಕರೆಕ್ಟ್ ತಾನೆ? ಈ ಥರದ್ದು ಒಂದು ಕಾನೂನನ್ನ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಹೇಗೆ ಸಾಧ್ಯ? ದಟ್ ಈಸ್ ವೇರ್ ದ ವೆರಿ ನಾವೆಲ್, ವೆರಿ ಯುನೀಕ್ concept of consent manager has come into existence. So the bill envisages a concept called a consent manager. This consent manager will essentially be a technical platform where every single Indian citizen who is essentially a digital nagarik can enforce his rights and duties using the consent manager to act on his behalf. Now the consent manager will essentially be an application, correct me if I am wrong Sharaji, it will essentially be an application which will tell you which particular data fiduciary, that is a particular data application that is seeking your data, who is seeking your data, what is seeking, why is it seeking your data, what is the duration for which it is seeking your data, just using the consent manager platform, which is by the statute itself defined as an interoperable platform, meaning it is like our UPI. So ನೀವು ಯು ಪಿ ಐಗೆ ನೀವು ಪೇಟಿಎಮ್ ಅಲ್ಲೂ ಯೂಸ್ ಮಾಡ್ಬೋದು, ಫೋನ್ ಪೇಲೂ ಯೂಸ್ ಮಾಡ್ಬೋದು, ವಾಟ್ಸ್ಆ್ಯಪ್ ಪೇಲೂ ಯೂಸ್ ಮಾಡ್ಬೋದು ಅಲ್ವಾ? ಅದೇ ಥರನೇ ಕನ್ಸೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಇಸ್ ಆಲ್ಸೋ ಗೋಯಿಂಗ್ ಟು ಬಿ ಅನ್ ಇಂಟರ್ಆಪರಬಲ್ ಪ್ಲಾಟ್ಫಾರ್ಮ್. ಅದೊಂದು ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಇಟ್ಕೊಂಡು ಯು ಕ್ಯಾನ್ ಗಿವ್ ಯೋರ್ ಕನ್ಸೆಂಟ್ ಆರ್ ವಿತ್ಡ್ರಾ ಯೋರ್ ಕನ್ಸೆಂಟ್. You can monitor how your data is being processed, by whom it is being processed, for what period of time it is being processed. Is it being processed even after you have withdrawn consent? If there is a data breach, what to do? Who to approach? What is the redressal mechanism? All of these things can be managed using a consent manager application, which is a simple technological application which creates a happy marriage between technology and legislation. This is a unique innovation that is done only in the Indian legislation space today, and no other, whether the GDPR, the Singapore, the Australian, the American, no jurisdiction, no legislation has envisaged a technical solution to enforce the rights and duties of the digital Nagrik. This is the game-changing aspect of this legislation. Adbhutvagiruvanಥ legislation ide, which is why you have not heard a single complaint about it from the usual suspects. So, as we are moving towards a $5 trillion economy, where $1 trillion will be fueled by India's digital economy itself, this is a landmark legislation which is going to pave the way and show the way for the rest of the world to follow, to regulate individual rights in a digital space. I would want to, on behalf of all of you, and on behalf of a very hopeful, very optimistic, very ambitious, very audacious, and a very youthful India, thank with a lot of gratitude our Honorable Prime Minister Narendra Modi for leading this effort to make the rights of every single digital Indian protected and show the rest of the world how this is done. And I want to thank Ashwini Vaishnav ji and Rajeev Chandrasekhar ji and all those people who labored hard to make this legislation a reality. I thank you once again for being such a wonderful audience today. Sansadhwani, sir, is a platform that we have created since I got elected as an MP. Ever since then, this is the 8th or 9th edition of Sansadhwani. Whenever there is an important legislation that the Parliament of India legislates, we organize a program of this kind in our constituency to create awareness among the public, because the law is made for the benefit of the people, and it is the people who empower us to make the laws. So it's a platform for accountability of public, and I'm extremely happy that just this morning, when the Honorable President of India has given her assent to the bill and made it an act, Bengaluru South is debating, discussing this very important legislation. Once again, thank you, Rajeev ji, for making time for this. And Sharad ji, thank you so much. You have always been there whenever we have sought your help. Elrigu namaskara. Thank you.
Thank you, sir, for sharing your thoughts on DPDP. This is indeed a very significant milestone in PM Narendra Modi's vision for India's digital economy, largely driven by digital Nagriks. Thank you, sir. We now look forward to a very engaging Q&A session with this very interesting mix of smart minds from various domains. As we open for Q&A session, request you to keep the questions short and clear. Please raise your hand and the mic will be handed over to you by our team members.
will start with Navi, sir.
Mike.
Thank you, Mr. Surya and Mr. Rajeev. In fact, people in South Bangalore are actually flying in the air for two reasons. One, this particular kind of bill, which we have been trying to look at for last several years, in 6 days, 7th August, 9th August, 11th August has become a reality. Okay, that is a great a feeling. Many of my friends who are here will have the similar feeling. So in this context, I would like to also ask, let Bangalore have one more feather in its cap. We are looking for Data Protection Board to be headquartered in Bangalore. Can it happen? It will be a revolution, as much a revolution as we have given GDPR aside and made a separate, like that, put Delhi there. Every institution goes to Delhi. Why can't we have a Data Protection Board in Bangalore is my request. And we will all be very, very happy if that can happen.
So first of all, I think that Tejasvi, you will have to carry that request to our big boss, the Honorable Prime Minister. Illala, Nano, I will certainly support that. But on a serious note, the institutions that we are designing in the cyberspace for regulation, adjudication are all digital institutions. So, for example, we have done one experiment with something called the Grievance Appellate Committee, which is to address grievances on social media. And it is purely digital. So there is no office, nobody has to go submit anything in physical form. We expect the DPB to be like that. So it is reasonably unimportant where it is going to be located, because for all the citizens that actually approach the DPB or indeed the platforms, they will be approaching them through a digital interface. And so therefore, I would like your ideas on what the UX should be. But certainly, there will be a back office for that. There certainly will be required to be a back office. And I will, along with Tejasvi, communicate the overwhelming desire for the DPB to be in Bengaluru.
Sir, namaste. I'm Prasad from BTM. Actually, I just have one question. I'm in the education sector. I just see that many databases are sold, like, just for the, if you just pay about 3,000-4,000 rupees, you get 50,000, 1 lakh, 2 lakh databases of engineering students or whatever it is, like MBBS students like that. So these personal data, how do you think this can be controlled? Even they have a privacy as well. How do you think these databases companies, there are vast companies across India, there's an N number of companies in there. How do you think this will affect them, and how are we going to control them?
So first of all, let me tell you very clearly, which I said when I was speaking, there is going to be a break that is put on this practice. That what you see today happening without any consequence and without any sort of a opportunity for those who are on the other side of this, whose personal data is floating around, to get any justice or put a stop to this. Therefore, this bill puts a stop to this. And I'll explain to you how. First of all, when the bill becomes notified after the transition period and goes into effect, every data fiduciary, that is the platform, will have to inform all those whose personal data they have with them. So assume that there is a day zero when this bill comes into effect and is applicable to all data platforms. And many data platforms may have data that they have collected over the last 10 years. On that day, they have to approach, they have to send a message, they have to send a WhatsApp, an email, whatever, to all of those people whose data they have, which is personal data, and seek either their consent. And if the person whose data they have says, but I never gave it to you, I don't know how you got it, and I want you to delete it, The right goes to the consumer, the citizen, to say, don't keep my data. So, two answers to your question. The current practice of databases being sold will fall afoul of this law, and anybody who does that will be violating this law, and the consequences will follow from that law. The second is, anybody who uses personal data from one of these databases without having taken consent of the person whose personal data is will fall afoul of this law, and the consequences will fall in as per the law. So, to explain to you today, at a broad level I'll explain to you, and there will be many more discussions on the granularity of this law as we go forward, is that the present practice of many platforms to take personal data and then sell it will now stop, because that selling will be under misuse, exploitation, and violative of this law.
And it is likely to be implemented.
So we will give the industry some time to transition. We cannot do it tomorrow because everybody has to adjust. That we will do in consultation with the industry. I have already spoken about this. We think that the big tech platforms will be given a shorter time. Some of the startups and some of those who require a little bit more time to transition, we will give them a longer time.
Hello.
Let's see, yeah. So I'll give you an example. If you apply for a loan, then you go to one of these screen scrapers. They take your password. They literally take your bank account password and they open up your bank account pages and then take a picture, put it in a report, and then give it to the lender, because the lender wants to know exactly what the actual status is, right? This is actually an illegal practice, but is very common. It has been very common. Now, when this consent manager that was being talked about, because this is implemented in the financial data space, when that came about, the first place where you saw this come down dramatically is actually screen scraping. I won't mention the name of the companies. They also happen to be Bangalore South companies, two of them who were market leaders, and they have suffered because that screen scraping report used to cost 40 to 60 rupees. Now you can do the same thing with consent for 75 paisa. So why would you not prefer to do it for 75 paisa? And this is better for the bank because they're getting authentic information electronically through the consent manager, and which is reliable versus the screen scraping. So when you build systems that are convenient to use and are friendly to the citizen, then even without a lot of regulatory oversight, the whole market begins to move towards the right direction. That's the beauty of this system that has been created today. So you should be optimistic that many of these things will start going away as we look forward.
Hello. Yeah. Thank you so much for bringing the DPDP Act, and thank you so much for not keeping it a copy of some other country, first of all. And I'm Kunal from Rich Webs, and I have a vast years in digital area. Okay, so I have two questions. One is a scenario and one is a particularly question for why this is a DPDP, why is it Digital Personal Data, not a Personal Data Act, first of all. Because suppose when this bill or act has been declared, the people will do print out and they will use it as a hard copy, and they'll say it's not digital, it's a copy. Okay, second part is a scenario where I was just coming from Mysore. Okay, and in the car, we are just discussing about that there was an advertisement and we just crossed. It's called a Kaveri Siri, a project. So we just saw and we just talked. After coming, we have an advertisement of Kaveri Siri on our phone. So how that is going to tackle on this particular act, and how we can stop it?
The first question about why it is Digital Personal Data Protection Bill, because this deals with personal data in the digital domain. And for most of us, or at least most of the world today, that is the area that is of most concern. Now, if somebody has a register and is writing something in the register, and from that register takes some personal data, that is a bit of an outlier issue that this bill certainly makes no attempt at addressing, and it is something that will be addressed by maybe the CRPC and the IPC when that new law is prescribed, which is that you should not violate privacy, full stop. So that is the issue on digital personal data, and that is, as you know, that is where most of the misuse, most platforms are today misusing and exploiting data and creating all kinds of databases that are then used for other purposes, etc., etc. And that we wanted to certainly bring some halt to it, and that bill does. On the issue of use of your personal data, now let's say you've given your data to a food service delivery platform or to some other platform. Can that food service delivery platform use that data for any other purpose other than that they have specified in the consent and have got the consent for? Answer is no. If you want to use targeted advertising, that has to be in the consent form, and we are very clear that we have kept the control on consent to be something that we will specify as a government. That means we believe this will evolve. The nature of informed consent will evolve, and it is not some model that we agree on today. But it is clear that we want two things. One is that the consent should be only for data, minimum data that has to be required for the service. There is an obligation that is already casted on the platform. But if the platform says, can I also seek your consent for targeted advertising? Prima facie in the law, there is no prohibition. But you have to give the consent for it. So, but without consent, there is no question of any platform using that data they have collected from you for any other reason apart from delivering that service.
The just two things that I would want to add. One, though, Rajeev ji mentioned why this is controlling the digital space and print out ಮಾಡ್ಕೊಂಡು ನಿಮಗೆ ಪ್ರಿಂಟ್ ಔಟ್ ಮಾಡಿಕೊಂಡು ಅನಲಾಗ್ ಫಾರ್ಮ್ಯಾಟ್ ಅಲ್ಲಿ ಯು ಕೆನಾಟ್ ಬಿ ಕಲೆಕ್ಟಿಂಗ್ ಆರ್ ಪ್ರಾಸೆಸಿಂಗ್ ಡೇಟಾ ಅಟ್ ಸ್ಕೇಲ್. ನೀವು ರಿಜಿಸ್ಟ್ರಿ ಇಟ್ಕೊಂಡು ಬರ್ಕೋತಾ ಹೋದ್ರೆ ಎಷ್ಟು ಜನ ಪ್ರಾಸೆಸ್ ಮಾಡ್ತೀರಾ ನೀವು? ಸೊ ದ ರೀಸನ್ ವೈ ದಿ ಲೆಜಿಸ್ಲೇಷನ್ ಏಮ್ಸ್ ಆಟ್ ರೆಗ್ಯುಲೇಟಿಂಗ್ digital personal data is because it's only when personal data is on the digital space that it can be operated, used, abused at scale. That is why it is aimed at...
No, but there is... Tejasvi is right on that issue, but I certainly missed that point about using printout. Please understand, when you print out a database, that is a breach. Because you cannot have a printout of a database where that printout is then used outside the organization for purposes that are not specified in the consent. The person printing out the database is printing it out from a database. That database has been constructed on the basis of consent. So that is not the scenario I was saying that the bill does not address. That the bill addresses. It is not possible. But what the bill doesn't address is, for example, if you go into your flat, and the security guard writes down your name, your telephone number as a visitor, and then somebody takes a snapshot of that and uses it. Or you go to a grocery store and that person writes down something. That in the register doesn't come under the DPDP bill. That is a narrow exception, and I suspect that a broader provision of privacy at large will be dealt with this, the CRPC and the IPC amendments that Tejasvi mentioned that the Home Minister is bringing to Parliament.
Sir, also with respect to targeted advertising that you said, the bill expressively prohibits targeted advertising with respect to children. Yes, yes. So that is taken care of. Yes, we had a question.
Hello, I am Arun Kumar from BTM 4 Stage, Bengaluru. I have two questions, sir. Number one, we are already shared our lot of data with, say, Google Photos or Facebook, Amazon, Flipkart, and so many other things. Okay. So how that data will be protected here afterwards? That is number one. Number two, how much cost of this data protection will be transferred to the end user? say a bank customer will he have to bear the cost of data protection like that? Thank you.
First question I've already answered. And what will happen here is, I just want to explain this carefully so that everybody gets it, is that there is going to be one day zero when the bill goes into effect. Before that day zero and now, when the laws come into effect, there is a transition period which will be time given to all of the companies to adjust and be ready for that day zero. On that day zero, or even before, all the platforms that have your personal data that you have given in the past or taken from you in the past will have to come to you and tell you, Mr. XYZ, I have your personal data with me. Do you consent for me to keep it? And if you choose not to keep it there, you can say, no, I do not. And they are mandatorily under law required to delete it. So there is one day zero, which is when, to give you a sense of the importance of consent, from that day onwards, any personal data that any platform has will only be with consent. And so all of these last few years that we have taken data with or without consent, those will all get normalized to that starting point that without consent, nobody can have your data. Number one. Number two, good question that you asked about cost of compliance. That is why this bill casts no onerous, difficult things on startups or companies for compliance, and therefore an argument that there is a compliance cost that we want to pass on to the consumers. It is very easy to comply with. Yes, if you are a startup today or a company today that is running a server in situ and you have all your data lying there with hundreds of people who are having access to it, or have hundreds of people given APIs, unfettered access to it, and it's all very leaky, then you have a problem. But that is a behavioral business process change problem. There is no huge amount of equipment that you have to buy or some great technology you have to buy. Of course, you will have to buy some firewalls, you will have to make sure that your systems are cyber secure. All that you will have to do to prevent hacking and breaching, which anyway most companies are doing. So I don't see any great incremental cost that will cause any, let's say, inconvenience or increase in cost for any of these startups and companies. Number one. Number two, that is by design. We have made sure that that is a policy objective that we meet, as Tejasvi said, we meet, not balance. That is the only thing I want to correct. It is not a balance. It is completely meeting the objectives of meeting the fundamental right to privacy and data protection, and completely meeting all of the reasonable, fair requirements for the innovation system to grow. There is no compromise on either of those, and completely meeting government's emergent requirements to lawfully access personal data in the event of national security, pandemic, earthquake, etc., etc.
Yeah, go ahead. See, I want to mention this consent thing. While the law has activated it now, MITI actually created an electronic consent artifact as a national standard on 23rd of March 2017. And then it has been piloted, as I told you, till 2019, then public pilot in the financial world till 2021, September 21. And after September 21, over 100 scheduled commercial banks are now using that same system. And that same system in terms of electronic consents in the financial world, same exact system, is growing at 32% month on month, right? So what has happened is, to allow these banks to adopt this system, a number of TSPs have come up. So at last count, there are about 30 or so technology service providers who can go to this and make it happen. And the cost of a bank adopting it has fallen already quite dramatically. Insurance companies have come on board. You can find all this information in sahamati.org.in, right? And so the TSPs are listed there, the metrics are listed there. So all that is happening is that what has been a successful experiment now can go into many other sectors. By the way, this was also the same electronic data consent artifact has been used in ABDM, in something called personal health records. So there is an evidence that the same electronic data format which remember is auditable, notifiable, secure, revocable, etc., and purpose specific, can be used in several sectors. So please expect this rollout in the marketplace to happen relatively quickly. There'll be some companies that will complain, not because it is difficult, but they don't want to do it. But those who want to do it will be able to do it relatively quickly and smooth and seamlessly as we go forward.
And just to add to what Sharad said, while there is this effort on MeitY's part, etc., there is no monopoly that there will be just one consent manager or one consent platform. There can be, and we will encourage many different consent platforms, consent management platforms across the board. So that will all proliferate as as the DPDP gets more and more awareness and people start responding to it.
Thank you so much for the presentation. Truly a historic day for the country, and a moment of silence for all the scammers who are going to not have their livelihood happening very well. My question is, how do you see, you've spoken a lot about consent and the importance of it in this bill. How do you see the difference between informed consent and going forward in terms of how the bill is going to be implemented? I think the burden, probably the worry as an end user is what is the burden on the end user, especially vulnerable populations, semi-digitally literate populations. What will be the burden on them to sort of raise complaints or go after data breaches, etc.? And very quickly, I love what ONDC is doing to have like a layer of dispute regulation startups. Is that something that you have planned for this as well?
So point number one, I think like I said, consent is fundamental in the architecture of this bill, and it's fundamental in the recognition that this is a fundamental right, and therefore there is a right and there's a reciprocal obligation. And the bridge of that reciprocity, if you want to call it that, is consent. Now, the word informed consent has been used here. So we don't believe consent is just the I agree that Tejasvi was referring to, that it has to be informed. And therefore, in the bill, we have hard-coded the need for the consent to be in multiple languages, to be informed. And also, we've talked about visual for those who are illiterate, to the point you're making, who are not literate or digitally literate, to be able to also seek the ability to do consent in a more graphical, virtual manner. So we've talked about not just languages, we've also talked about that. So helping inform consent is something we've built there. The third leg of this is we have retained in the bill the ability to notify in the event, and we anticipate that in the future, this consent architecture will go through evolution and innovation and modification. And the consent as we know it today, the Apple iOS download form or the other forms that you see 3 pages later where you have to do an agree, I agree, or the European model of the clicks that says no, no, yes, 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 no, no, that all of this will evolve. So we have even given the government the ability to notify a certain consent architecture in the future. So informed consent we take very seriously as almost the heart and soul of ensuring that the rights of the citizen are really rights of the citizen that are exercised well, meaningfully, and in an informed manner. In terms of grievance addressal, very simple, our success with grievance addressal for social media. And the idea of grievance addressal for us is not that we take on in the government more and more the role of being an ombudsman between a platform and a citizen, but to create a disincentive for the platforms to ensure there is grievance. What happened, I'll give you an example. 1 year ago, there was a lot of complaints coming to me, my social media account is amplified, shadow banned, deleted, banned, all kinds of things. So as a minister, I thought my inbox would have all these complex emails on policies and all of that, and I was getting 90% of my emails were about my account being And it turned out that the grievance addressal mechanism that these platforms had been mandated to build, they were giving a shortcut to. So a lot of people would get a grievance, and I saw a lot of responses from platforms that says, thank you for your grievance dated so-and-so, we will revert to you. And then it went on into a cold storage or silent. So we said, okay, fine. Then if you can't solve this as yourself and you can't behave responsibly, the government will create a grievance appellate committee where the consumer has the ability to appeal the non-addressal or a unsatisfactory addressal of a grievance to a platform. And that has caused a complete decline in dissatisfied grievance handling. So similarly, same model we are using here. We believe the DPB, the fact that it's digital, is very easy to approach, very easy to complain, will make sure that platforms behave themselves much more responsibly, much more responsively to the promise they've made to the citizen or the data principal for not breaching their data, for protecting the data, keeping the data in an accurate form, etc., etc. And when there is a violation, it goes to the DPB and the penalties are imposed.
Consent, which is a very important topic. I think the bill provides for best practices to emerge. And I think where India has already learnt is that if you allow for notifiability and revocability, then people very quickly learn that, look, I made a mistake, I over-consented. But I can now go back and correct it because I can revoke my consent. So there's a human citizen cycle that is at work. And that works very quickly is what we are learning. And this bill provides for revocability and notifiability is built into the system. Now we have to create best practices that manifest in the market. Now for them to manifest in the market, we want consent managers not to be agents of data fiduciaries, but the agents of data principals. And the bill again is very clear that this is what it will like to see happen in the market. So I think if we now do the subsequent regulation and drive the forces correctly, we will have consent managers who are agents of the citizen, not of the data fiduciaries, and the citizens have a learning cycle and trust the Indian. You know, when UPI came out, everybody thought, you know, how will ordinary Indians use it? Has that been a problem? Indians are, native intelligence of Indians is the highest in the world. So we must have faith in them and give them the tools, and a good system will emerge from that.
Yes, so that the gentleman at the back who asked me about the data you've given to Google Photos, whatever, this is the point I missed saying, which is that in this law, in this bill, you have the right at any point to revoke your consent. If you've given it today because you were having a late afternoon and you was drowsy and you gave it, and tomorrow morning you decide that you want to revoke it, you can revoke it. So that right is an absolute right that you can keep changing your mind. There is no need for you to think, if mera data means I have given the data, oh my God, what happens to it? Yeah, and in perpetuity.
You asked the question on the vulnerable sections, how they would be taken, and the semi-literate population, etc. The burden of proof that's wired into the legislation places the burden on the data fiduciary to prove that you collected the data in the right manner and through informed consent. It is not on the data principal. So the individual or the user of a platform need not prove that his consent was taken properly. It is the responsibility of the platform to show that we procured the consent in an informed manner, in a legally prescribed manner. Just like how the burden of proof in a criminal prosecution lies on the prosecution to prove that a person is guilty until proven otherwise, here the burden of proof lies on the data fiduciary or the platform to say, I got so-and-so's XYZ's consent in a prescribed manner as prescribed by the legislation. So it solves 80% of the problem.
Excellent point. I think the two people on the panel know more about this than sometimes I remember. But this is an important point because this bill is a sharp contrast with the data protection regime under the IT Act. You know, the IT Act currently also has data protection, and any violation there would have put the onus on the data principal to prove that they have been prejudiced by the breach before any action would have been taken against the data fiduciary. Here it is the exact opposite, that a data principal can complain that a breach has happened, and it is for the data fiduciary to prove that that breach happened, it did not cause harm, and therefore the penalty should be lower. So it is an absolute 180 degrees, and the asymmetry has been moved in favor of the individual, the citizen, away from the big tech platform that the IT Act conceptualized.
We'll take 2 more questions. Minister has...
Yes.
Time for 2 more questions.
Yeah, 2 more.
Yeah, sorry. Namaste, sir. My question is with respect to the cross-border data transfer. So I've read that as opposed to what European Union and others have adopted, not that it's in any way superior, we have adopted a way of blacklisting jurisdictions with which we share data as opposed to European Union where they've adopted the whitelisting way. How is it beneficial?
Yeah, it's a good question. When we put the first draft out, our instinct at that point was that we would whitelist. That means we will create these trusted geographies as a list, and therefore data processing in these trusted geographies will be permissible. That was how we started this. And that seemed very logical because the cloud can be in these trusted geographies. But we were certainly not of the view from day one that we want to do hard-code localization. Because we certainly believe that our startups must have opportunities and choice to which cloud they use, where they use, which data center, etc. So it was clear in our mind that we wanted that multiple choice to be available. But the whitelisting moved to this blacklisting model because we think the whitelisting then has a lot of other government involvement, and then we keep having to say, okay, today the USA is whitelisted, tomorrow the UK is whitelisted. So instead the approach now is the whole world is permitted unless the government of India, the Home Ministry, the External Affairs Ministry, as this bill gets rolled out and as we understand, determines a particular jurisdiction is not trusted because either the law does not apply there, that is this DPDP as a law, that jurisdiction contradicts this law, and or that there is a consistent pattern in some geography where the data is not being able to be protected and there's breaches and there is misuse and exploitation. So progressive blacklisting of geographies is the approach that we are taking, and I think that is less disruptive to the innovation ecosystem that is being built out and is galloping so fast, but also addresses the issue that we don't want it to go to untrusted geographies or geographies where this law doesn't apply.
Yes, yeah, this is Anand here. I'm from Banshankari, and we've spoken a lot about data protection. Would you throw some light in the IT Act about intellectual property protection and how it has impact on, data protection has impact on this? Is there anything planned on that?
So I'll be very clear, the DPDP, this bill doesn't deal with it at all. But the companion bill that I referred to in my conversation is what is called the Digital India Act. It has a whole section on intellectual property and digital intellectual property. And when that comes out, hopefully that consultation will start 3rd week of this month. We will certainly come to all of those who are interested in the subject and seek their views. Yeah.
There's something that we Indians don't appreciate. You know, India was the first country in the world to not allow for software patents. You know why? Because we believe in intellectual property being protected in software. But just like music, software is a collection of notes. You don't have patents in music. You have copyright in music that prevents this from happening. So the argument in India was that since software is like this, it's like mathematical thing, we should not have patents. Why? Because the patent system in the US is broken. It no longer works in the favor of the challenger. It works in the favor of the incumbent. And our fear was that they would come in and destroy our companies here like Tally, Zoho, and so on and so forth. Now that idea has taken root, so much so that the first country that copied us was New Zealand, Australia, now Europe, and believe it or not, last year China said that they would like to follow the India model as they go forward. So look, I want to leave this thought in your mind that when we think from first principles, we are the only country in the world that can think at 3 levels of abstraction: Bhajan, Gita, and Veda. When we get to Veda thinking, because we have the capacity to do that, everywhere in the world they can think, bhajans, they can think Gita, but they can't go to first principles like we can. Every ordinary Indian can do that. And when we start doing that for the stuff that we care about, we come up with outcomes that are suitable for us. They happen to be also relevant to the rest of the world. So have faith. I think we will find the right answer for this modern world and how to apply intellectual property in the AI world and all of that as we go forward.
Yeah, so the reason I spoke about the intellectual property protection is I'm probably a CEO of a company which has really borne the brunt of this kind of piracy. We were probably one of the first companies in the Indian language space to go public in 2000. And today we have been almost run to ground because the software that we were selling in the market, you might have heard of it, called Akruti, was sold. What we were selling in the market for about 2,000, 3,000 rupees was being sold at 30 rupees in Lamington Road at Nehru Place. And our revenues drastically crashed. What promises we made to the public? That, there's a huge, because that was those those days were not called startup days,
Side conversation, usually this needs a techno-legal approach, and we can talk about it and how to apply that to make that happen within the current ambit of the law.
No, wait. I just want to, I'll tell you the government view on this, whatever be the ideological and philosophical view on this. We certainly place a value on intellectual property. We see in our tech space today, there's a whole spectrum of activities that are creating very, very rapidly intellectual property that are India-centric. We certainly believe that digital intellectual property is an area of our attention. And the Digital India Act has a whole chapter on that. We will certainly discuss that with you when the DIA is open for consultation.
So last question. I've been in the space for 14 years in communication space. So what I've realized is that there was one bill there was one regulation called unsolicited commercial communication that's been around floating for a while, and I think we all know how we've gone through that phase for the last 14-15 years. I think we should look at that, making that stack, make it a subset of DPDP, because it also talks about consent, it talks about preferences, choice of communication, preference, what time, which data fiduciary I can say no, it does in the recent. It also uses underlying blockchain technology that's currently launched by telecom service provider. It's in place, so maybe we should look at that as an opportunity to bring it under this gambit of things in DPDP. The other thing is that I'm looking at consent manager as a stack. I think we should look at not just for India but also for the world. We should export this, make it open source. Yeah, we should make it open source. Maybe a couple of other countries in South Asia and all of them can use it as well.
Hundreds and thousands of companies that are running consent management platforms.
Sir, I have one request from the Honorable Minister, and Sharaji wants to make some closing comment. I mean, he wants to add something. Sir, both of you, this concept of consent manager is central to this legislation, because that's how the legislation finds itself in action, and the rights, duties gets enforced, etc. So, because it's an audience that can also appreciate technology and how it is, how this can be made, maybe if you can take, a couple of minutes to explain the a consent manager in action, how that would be.
This opportunity before it, and he can make the closing comment. And I want to compliment the minister because I'm going to give him credit for bringing $1 billion to the exchequer, taxpayer, as a result of what is happening here. Let me tell you this story. So look, the West wants personalized ads to be delivered to you. They don't want any of you to receive the same ads. They want to personalize the ads, right? And that's very important to them. It's a rich economy. They want to shape how you spend your money, and therefore advertising is very important. This is not important for India. In India, the nirvana for us is when we can give customized financial products to our people. Where when you apply for auto insurance, you, sir, don't get the same rate as her, because your driving history, your driving style, how long you drive is different from the one that she drives, right? And so therefore there's no reason that both of you should get the same insurance. Insurance should be personalized to the individual. Similarly, if I am looking for a loan and my capacity to pay is limited, I should still be, even a beggar should be able to get a 200 rupee loan for a day. And if he repays back the next day, he can get it for another day till he's established his credentials so that he can get it for a month at a time. We need to create an economy which will personalize this for the ordinary citizen. Not only personalize financial products, education. What should be my study plan should be personalized. What should be my health plans? When you go to an Ayurvedic doctor, he doesn't give you a generic prescription. He gives you a personalized prescription. We are a land which deserves personalized financial products, educational products, and health products. Now, let me very quickly explain to you why this is going to come about when you do this. Today, when you apply for an auto loan, what happens? You go to a company, many companies are there, let's say Policy Bazaar, and you give them all your personal information. And this personal information, then they share with 5 insurers. They give you an offer, and then you pick from one of those offers. If this intermediary now has all your personal information, where did you go, what happened, this, that, and the other, you don't want that intermediary to have personal information, because that intermediary may misuse it. And why should you give it to this extra person? You wanted to give it to the insurer, not to the intermediary. Now a Bangalore South company, which for reasons we will not go into, ended up being acquired by an American company, decided that they can do this the correct way using the consent manager. So they are saying that, look, when you want to apply for this loan, I will merely act as a facilitator, as a consent manager. Because when consent manager allows for your data to go from you to all those 5 insurers, they themselves don't get to see that data. So they are saying you can trust me, therefore, to help you get the most personalized financial product that you can. Now, to do that, they have to be not a Singapore domiciled company. They have to be an Indian domiciled company. So they came to Government of India and said, what will it take for us to re-domicile back? And our Indian government did some back tax calculation and said it will cost you $1 billion in back taxes. They are happily paying that. This is the power of this new system that will emerge. This second generation of kind of marketplaces in finance, in health, in education, and India is the epicenter. Why are they paying this? Because if they can make this work in India, they can make this work anywhere else in the world. So this is a tangible example of a consent manager enabling a level of personalization without having the intermediaries, the Google, the Facebooks, the Policy Bazaars becoming the bad characters that we have, because we have an alternate system where you don't lose out. You still get your full personalization and you have full protection. This is the new system that will come in India, and India first before anywhere else in the world.
Yeah, no, so look, again, thank you for all of you spending a Saturday evening where you could have been watching Netflix movies, or I'm sure there'll be, but this was an important conversation to have. As I said, the characterization of that Sharad made about the bad actors and people who misuse and exploit personal data is a real, clear and present danger. But after this bill, that will certainly very, very significantly come to a halt. That's point number one. I can promise you that. That is the intention of Honorable Prime Minister, in that these rights that are being given to the citizens are real. The second is, I just want to tell you that in the cyberspace, everything is evolving. So these laws on day one there will certainly be some some gray areas, some lacunae that we will have to deal with through subordinate legislations, etc., etc. So there's nothing in the digital space that can be architected to work 100% in a foolproof manner from day one. So you will see as we move along, there will be a lot of evolution and so on and so forth of the bill and the other bills that are coming in the pipeline. Third, on consent, I certainly want to just repeat the point that consent is central to the bill. We see this bill working in a manner, it's a simple enough proposition, that over the years, the consent will be directly between the principal and the fiduciary. It is the platform of consent managers are specifically in the bill to facilitate those who cannot give informed consent at this stage of the legislation or this stage of their own digital development. So consent managers are basically to help those who can't deliver on the need to give informed consent at the beginning of the life of this bill. Now, yes, in the past, the consent manager was a layer between misbehaving platforms and gullible citizens. I think the misbehaving platforms will certainly be addressed by this bill very sharply, very clearly, very decisively. It's a mission for this government to make sure that happens. And so therefore the consent manager role, it will continue to have some of the functionalities that Sharad says, but it certainly the primary role will be to help more and more people who are going to join the internet from the 83 crores today to the 120 crores by 25-26, that they can come into the internet, access these platforms, avail these services, gives consent in an informed manner, even if they don't quite understand what they're consenting to or what they're being, what the data is. So that consent manager becomes a layer there to further strengthen the role of consent in the bill. Otherwise, everything has been discussed, and I think this has been one of the more complete and comprehensive conversations that we have had. Congratulations to South Bengaluru's audience. Congratulations to the South Bengaluru MP, and congratulations to South Bengaluru's Sharad. So all the best, and have a good weekend, all of you. And I hope you'll think a little bit more about digital personal data protection.
Sir, with your permission, last question from the student community. Yes.
Hello, sir. Hello, sir. This is Jagdish from BMS College of Law. So my question is that why is the Data Protection Board, why is it not autonomous? As in, the central government has been given vast powers. For example, Section 40 has given central government that they can make various rules regarding data fiduciary, data principle, and how it applies to them. And also that Section 17 as well, Section 17 2 and 3 gives majority powers to central government itself. Why not give these powers to the board instead of the central government? Because central government is the largest data holder as well. The repository, the largest data repository holder is the central government. Why does it have majority powers? Is what my question is, sir. Government against Allah, sir. Why is it not with the board is my question.
No. Look, it's a question that is being asked, and let me answer it this way. You're a law student. So let me just explain to you that this autonomy, independence, this word that is used interchangeably, is not clear to me what that is supposed to mean. If it is distant from the government, I understand. But in this bill, what is most important is an accountable data protection board. A data protection board that delivers on what its responsibility is. Whether it is independent and unaccountable versus whether it is appointed by the government and accountable, if you have to choose between the two, you must choose where accountability comes in. And this bill designs the data protection board to be very accountable from day one because A, this entire jurisprudence in the data space is going to be now created by the Data Protection Board. And there is an appellate jurisdiction of the TDSAT, which is chaired by a retired Supreme Court judge. And then the final appeal is in the Supreme Court. The accountability and the performance of the DPB is determined by the quality of its appellate jurisdiction. So I have been an entrepreneur, and I can assure you, without telling you too much detail, I have dealt with so-called autonomous organizations in India and independent organizations in India. There are several cases of capture of so-called independent organizations. So without giving the accountability. So we have thought through this very carefully. We are more interested, and first of all, the DPB is independent of the government. It is independent of the government, it's not government. But we have stressed that the institution that is so important for the adjudication of these disputes is accountable through the way its performance is overseen, first by the TDSAT and then by the Supreme Court. Yeah.
I just want to add to what Rajeev ji said. You're a student of law and you understand that the power to make rules is something that cannot be delegated to a body that is not the Parliament of India. Correct? Therefore, it's only the central government that can make rules governing the space which will need to be ratified by the Parliament of India. You cannot be outsourcing a sovereign function to a board. So the power to make the act as well as the rules thereunder is essentially a sovereign power of the Government of India and ratified subsequently by the Parliament of India. So the power to make rules necessarily has to rest with the central government. So that's the... You refer to section 40. I went through section 40 is why I'm giving this answer. So section 40 mentions the power of the central government to make rules. Subordinate legislation only the government can make. It cannot be delegated to a board under a specific this thing. It can make, you can have notifications under of how it should be done, but the subordinate legislation practice is essentially a sovereign practice which the government with subsequent ratification of the parliament can do.
I'm sorry, I misunderstood your question. I didn't. He's absolutely right. What Tejasvi ji is saying is absolutely correct. Under the law, when we were making this law, there were two options. One is to hard code everything into law. Hard code everything into law, which means every time there is a change in the technology ecosystem, there is a new challenge, you have to go back to parliament and amend the law. So instead, this is an evolution, future-ready law that allows you to constantly change the subordinate legislations. And through those rules, you can keep meeting these new challenges, new opportunities. Now, the myth that somehow the subordinate legislation is less than a law is wrong for the same reason that Tejasvi mentioned, that the subordinate legislation also, that is the rules, also have to go to parliament, have to be tabled in parliament, have to pass muster in parliament. That is one. I thought your question was, why is the DPB not autonomous? Yeah. So, and the DPB, by the way, does a very narrow function, which is adjudication of disputes and breaches under the law. And it is independent. It is independent in the sense it's not government. Government does appoint the members of it. But the DPB is a very important institution. There is nobody today in the ecosystem that wants the DPB to be anything other than a high quality, global standard, adjudicatory body, because it is on the basis of that that investments will come, startups will succeed, etc., etc. So there is nobody even in the government who has any interest in making the DPB anything other than a very high-performing, global standard, accountable organization. I was making the point on this debate that some lawyers have about independent regulatory institutions. And I always say to them, and I have some experience in this, that actually the phraseology should not be independent. It should be accountable regulatory organizations, not even autonomous. It is that they have to be accountable for the quality of the work that they do, whether they are independent or not independent. And that ought to be the outcome and focus of all of what we say when we talk about designing new institutions.
So you started taking questions, more hands. 100%.
The whole genesis of this started with the 2013 PIL was because the Aadhaar was leaking so much.
So thank you so much. I mean, we started 5:30 and it's 7:45. and we have such an engaging audience who have been so receptive, so interested and invested in this. A big round of applause to all of you for making this such a successful program. Thank you so much, and thank you once again, sir. Thank you so much. Thank you. Right.
Yes. In conclusion, I would like to say we walk out of this session becoming a more empowered digital Nagarik. Thank you all for your participation and have a great weekend. Thank you.